Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade eImmigration. Choosing immigration software is one of those decisions that you feel for years. The wrong system slows your team down and adds stress to every case. But the right one makes everything feel more manageable. You need to be able to tell the difference. That's why the team at eImmigration created a free immigration software buyer's guide to help you make that decision with confidence. It covers everything from must-have capabilities to the 7 signs it's time for better tools. Find it at get.eimmigration.com/IRP and take the guesswork out of your software search. Or click on that special link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This week, the Supreme Court heard argument in the metering case, the Al-Atrolado decision. From Ira Kurzban, quote, "The case is clearly moot because it was about CBP agents pushing people away from the border, called metering, to prevent them from setting foot in the United States. But both the metering practice and the closure of the border have not been issues since July 2024 when Biden shut the border. So why is the case even at the court? The majority's focus on the language tells you everything that is wrong with the current court. After the Second World War, the world community rejected the horrific response of countries like Switzerland, Cuba, and the United States that refused to accept Jews and others fleeing Nazi Germany and Nazi-occupied territories, resulting in the refugees' deaths in concentration camps. The convention, and later on our own Refugee Act, reflected the world's revulsion and determination that we will never again turn people back at our borders who flee persecution. The court's majority, ignoring the history and purpose of why we have refugee laws, turned the oral argument into a semantic game of the meaning of arrive at versus arrive in. Shameful," end quote. Says Ira. Here's this far more measured assessment from Melissa Crow, the Director of Litigation at the Center for Gender and Refugee Studies, who has been litigating this case with others for years and who is part of the Supreme Court attorney team. Quote, "The government's turn-back policy ran roughshod over our laws and treaty obligations. It fueled chaos and dysfunction at the southern border, and it was a complete humanitarian catastrophe, returning thousands of vulnerable refugees to grave harm. For far too many, the turn-back policy was a death sentence. We are here at the Supreme Court today for them and for all people who continue to look to the United States as a beacon of hope and as a place where the persecuted may find safe haven. we will never stop fighting for the rights of people seeking safety at our nation's doorstep, end quote. Slightly more measured. And less interesting, this week the Fifth Circuit denied rehearing in its episode 299 decision Fuentes-Pineda v. Bondi and reissued the decision. Still quite rough for non-citizens. Not to be outdone, the Third Circuit made a stylistic amendment to its Sanchez decision from episode 277, issued 1 year ago. The pursuit of perfection never sleeps. With all that out of the way, I've got 6 decisions for you all, and none of them are particularly good for non-citizens. Such weeks do exist, although they are rare. I had a good week, though. Did you? Let's think about that as you listen to this. All right, folks, here we go. First is Herrera Avila v. Bondi, published by the 8th Circuit on March 25th, 2026. This is a devastating one for non-citizens. The 8th Circuit has essentially agreed with the 5th Circuit that, at least statutorily speaking, all EWIs are subject to mandatory detention. Judge Erickson dissented vigorously. Mr. Herrera is from Mexico. He entered the United States without authorization 2 times, in 2006 and in 2016, and it appears has lived in the United States pretty much that entire time. So like 20 years. He came into contact with DHS following what appears to be a routine traffic stop in August 2025, and he was put into removal proceedings, though the 8th Circuit does not mention why this stop occurred. By this point, of course, we are well into the second Trump regime, and the BIA had issued matter of Hurtado, so ICE kept Mr. Herrera in immigration prison, and an immigration judge denied his request for a bond hearing. He filed a petition for writ of habeas corpus in federal court, and the federal district court judge granted the writ, requiring that a bond hearing before a neutral, emphasis by me on neutral, arbitrator occur. When that hearing did occur before an immigration judge, lo and behold, the IJ, looking at Mr. Herrera as a person and looking at his life in totality, believed that a $7,500 bond was appropriate for this 20-year resident of America. At the same time, however, the Department of Justice appealed the habeas grant to the 8th Circuit, which has now overturned the district court on this very complicated issue. I'll get into it a bit deeper than I did in the Buenrostro-Mendez et al. V. Bondi decision from the 5th Circuit a few weeks ago. Not least of which because the 8th Circuit gave me more time. Now, to me at least, I&N Section 235 is about expedited removal and other border actions. Not necessarily so, explains the 8th Circuit. I&N Section 235A1 holds that, quote, an alien present in the United States who has not been admitted or who arrives in the United States shall be deemed for purposes of this chapter an applicant for admission, end quote. I&N Section 235B2A then reads that, quote, in the case of an alien who is an applicant for admission, if the examining immigration officer determines that an alien seeking admission is not clearly and beyond a doubt entitled to be admitted, the alien shall be detained for a proceeding under Section 229A of this title, end quote, meaning 240 proceedings. Now, you heard me say the phrase seeking admission, and that phrase, explains the 8th Circuit, is not defined by the INA. And it clearly qualifies applicant for admission in that statute for detention purposes, right? In the case of an alien who is an applicant for admission, if the examining immigration officer determines that an alien seeking admission is not clearly and beyond a doubt, blah, blah, blah. Clearly qualifies it, at least to me. Possibly to the 8th Circuit, too. That's kind of the whole ball game. Is seeking admission simply equivalent to applicant for admission under the statute, or is it a separate qualifier? Applicant for admission is defined in the INA, but seeking admission is not. If seeking admission qualifies the statutorily defined term applicant for admission, then there's some wiggle room on the argument. But if they are equivalent, it pretty much means all EWIs are subject to mandatory detention, at least under the arguments being made here. Also kind of makes the statute a bit redundant, but here I am again, me again. As in the 5th Circuit before it, the non-citizen here conceded that he was an applicant for admission. I'm not sure that's a necessary concession, but this is now the second case where it happened. And it means the whole dispute is coming down to what seeking admission means under the statute. Mr. Avila argues that a non-citizen, quote, only seeks admission under the statute when he takes an affirmative action to obtain admission into the country, not when he is merely present in the country without having been admitted, end quote. The Eighth Circuit, like the Fifth Circuit before it, disagrees. No court has held otherwise yet, although, quote, the Seventh Circuit, discussing the issue in the preliminary injunction context, has rejected this interpretation of the statute on the grounds that it would render the phrase seeking admission superfluous, end quote. That's Castanon Nava, the U.S. Department of Homeland Security, from 2025. So heck, maybe there's already a pseudo-circuit split here? Let's be honest, we all know this is going to the Supreme Court. Congratulations, BIA. To the Eighth Circuit, quote, here we agree with the Fifth Circuit that the ordinary meanings of the phrases applicant for admission and seeking admission are the same, end quote. The reasons are many. First, the Eighth Circuit dives into dictionaries and explains that when a person applies for something, they are necessarily seeking it. I'll remember that next time my wife is applying makeup. She's going to love that witty joke. Can't wait to use it. The Eighth Circuit also references the Fifth Circuit's college application analogy. EWIs are applicants. Always, the Eighth Circuit explains, just as college applicants are still applying after they submit their application to the college. I guess that's the same as coming into the United States unlawfully, or at least a proper analogy to the Eighth and Fifth Circuits. Also, the Eighth Circuit believes that the structure of the statute indicates that applicant for admission and seeking admission aren't to be treated separately. There is no use of the word if or and before seeking admission, for example, explains the court. The Eighth Circuit majority therefore rejected Mr. Avila's superfluous argument, stating, quote, since the structure of the text does not indicate that this phrase has standalone meaning, merely using it as a synonym for something else does not make it surplusage, end quote. Doesn't matter either that the phrase applicant for admission is a term of art with a statutorily defined definition, while seeking admission is not. The Eighth Circuit goes through some other provisions of the INA to highlight why this is so, logically speaking. The majority also believes that all this aligns with Congress's purpose in 1996, which, if true, is quite the cruel purpose. And after all, explains the Eighth Circuit, a contrary meaning would lead to a result such that Mr. Avila gets a bond hearing, whereas people who come to the border at a port of entry seeking admission, true arriving aliens, and who do not come in unlawfully, do not get bond hearings. That doesn't make sense to the court. As to Jennings v. Rodriguez, where the court interpreted Section 235 to apply to non-citizens detained at the border and Section 236 to non-citizens detained in the interior, well, quote, this characterization was offered only as general background information, as the court there was not confronted with the interpretive issue now before us, end quote. They will soon, though. They will soon. So too with a nearly 20-year-old Eighth Circuit decision, explains the court. In any event, the Eighth Circuit doesn't see Jennings' dicta as necessarily precluding this result. As to no presidential administration ever doing this before, well, that no administration ever wanted to be this cruel doesn't mean they couldn't be. Presidents, and by extension, your votes, matter. All but, says the Eighth Circuit. By the way, though, ICE always has authority on a case-by-case basis to release non-citizens, notes the Eighth Circuit in a footnote, citing to a Fifth Circuit footnote. What about the fact that the Laken Riley Act literally makes a subset of EWIs subject to mandatory detention? Doesn't that indicate that even Congress doesn't think that its original statute in 1997 doesn't make all EWIs subject to mandatory detention? Well, among other things, quoting Barton v. Barr, Episode 1 from the Supreme Court, quote, redundancy in one portion of a statute is not a license to rewrite or eviscerate another portion of the statute contrary to its text, end quote. Of course, it assumes you got the text right? Plus, explains the Eighth Circuit, there's all that stuff about how Congress was responding to the Biden administration. Its own kind of form of legislative history. Rejecting a legislative history argument, the Eighth Circuit wrote tens of thousands, if not hundreds, and who knows, future millions in the Eighth Circuit to immigration imprisonment without even the opportunity to have a judge consider them as a human being, or whether literally anything other than policy goals were achieved by incarcerating them in a private geo or core civic prison. And that's that. But also, there's this, the dissent. Judge Erickson wrote the counter opinion. And I don't really ever do this, I don't. But it is noteworthy that he was appointed by the current president. Quote, for the past 29 years, Mr. Avila would have been entitled to a bond hearing during his removal proceedings. The court now holds that Mr. Avila and millions of others are subject to mandatory detention. In doing so, the court does not rely on recent congressional action or a change in the regulations governing detention, but rather engages in a novel interpretation of alien seeking admission that eluded the courts and 5 previous presidential administrations, end quote. Judge Erickson doesn't believe the majority right on the text or on the concept of seeking admission. Among many other things, Judge Erickson explains that the ordinary application of seeking implies present action, namely, at the border. Quote, to get to its desired result, the court uses the statutory definition to deem Mr. Avila an applicant for admission, and then turns around and uses the ordinary meaning of the same phrase to find that he is also seeking admission when he is not, end quote. Those two terms are not the same, Judge Erickson explains. The canon against surplusage isn't always the end of the story, the judge explains, but here, Congress clearly used 2 different terms. Quote, a variation in terms suggests a variation in meaning, end quote. Judge Erickson explains why the history of IRIRA also doesn't support this result, and explains how IRIRA maintained the distinction between bond hearings for those inside America and none for those who weren't, even as it simultaneously put everyone into removal proceedings and killed exclusion proceedings. That is the point of the seeking admission language to the judge, to distinguish those at the border who then, like now, wouldn't get bond hearings. IRIRA's headings support this too, explains Judge Erickson. Not to mention the broad applicability of INA Section 236A that gives lots of people bond hearings, nearly unmentioned by the majority. 5 presidential administrations and Congress never tried to correct anything? Seems important for a court to consider for many reasons, including under Loper-Bright, explains Judge Erickson. The judge concludes by reminding the majority that the Supreme Court has said many times that non-citizens in the United States have constitutional rights, including the right to due process, and that we must protect that right, both for the non-citizens themselves and for Americans. And as such, he footnotes that in the 8th Circuit, as in the 5th Circuit today, due process-based habeas challenges to mandatory detention remain very alive and well. And that is Herrera Avila v. Bondi. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial Advocacy College. Registration is now open. The annual Immigration Court Trial Advocacy College convenes every year in April, only in Kansas City, Missouri, hosted by the Pen and Sword, that awesome community resource founded by Reka and Michael Sharma Crawford. This year, the program has been reimagined and reworked to address the current climate of aggressive deportation enforcement. These times are not ordinary, so the program had to be extraordinary. Expanding from 3 to 4 days, the Trial College provides comprehensive training from beginning to end, real cases taught by real litigators in real courtrooms. The skills you need, the confidence you deserve, and the mentors you look up to, all in one place. Register early to avoid disappointment at www.thepen-and-swordkc.org or at the special links in the show notes. Use special code ImmigrationReview26 to get $50 off the Trial Advocacy College this year. That's capital I, capital R. Next is matter of Mercado-Martinez, published by the BIA. This case is about Forms I-213, those omnipresent ICE police report things that are regularly filled with errors and that do, under case law, enjoy a presumption of regularity. Can the non-citizen bar get one presumption? Any presumption. Maybe a half a presumption, a portion of a presumption. All right, the past persecution presumption doesn't count, and as we've seen, the BIA is trying to chip away at it. But I've got to be intellectually consistent and complete in my attempts to be humorous, guys. So it gets a mention, An immigration judge terminated removal proceedings last July, concluding that DHS had not met its burden to establish Mr. Mercado-Martinez's alienage. Why did DHS have the burden? Because technically they always do. Non-citizens and their attorneys, and IJs who receive them, are just so used to non-citizens conceding that they are in fact aliens that we all forget that it's DHS's initial burden. Mr. Mercado-Martinez's attorney surely denied alienage, it would seem. That doesn't mean that he's claiming Mr. Mercado-Martinez is a U.S. citizen. It just means that the attorney is putting DHS to its legal burden. Quote, DHS has the burden of proving a respondent's alienage by clear and convincing evidence, end quote. That's 8 CFR section 1240.8c. A quote and citation for you should you need it in immigration court. By the way, the BIA notes that the burden is clear and convincing evidence in the Ninth Circuit, where these proceedings originate, but it's clear, unequivocal, and convincing evidence in the First Circuit. And that's a different burden. Rosa v. Bondi, episode 255. Might also be the case in the Sixth Circuit, if I'm not mistaken. Anyway, the thing is, when you deny alienage, DHS will often turn around and file its police report thing called an I-213, where some immigration officer alleges that your client is a non-citizen, sometimes based on something that they allege that he or she, your non-citizen, told them. In most cases, an I-213 will likely win the day, thereby shifting the burden to the non-citizen. And in the case of a non-citizen charged as inadmissible under a Section 212 ground, which is likely an EWI, it requires the non-citizen then prove that they are entitled to admission or that they are otherwise due reliefs. We're at the initial stage. And decades of case law holds that, quote, a Form I-213 is presumptively admissible and reliable, end quote. Don't ask why immigration considers some hearsay evidence better than others. It just does because we are immigration law. In this case, the IJ recognized that this presumption exists, but deemed the I-213 insufficient. Seems, though, that the IJ didn't really explain why. The BIA doesn't like that. Though, to be honest, if this was all happening in the First Circuit, that might still be the case, right? Is an I-213 clear, unequivocal, and convincing evidence? Give this some thought, First Circuit people. But we are not in the First Circuit. And true, quote, the presumption of reliability can be rebutted if there are material errors or inaccuracies in the document or evidence that the information in the document was obtained through coercion or duress, end quote. Citing some excellent Ninth Circuit and other case law for that proposition. But without any quotation for this, the BIA clarifies, again, at least outside the First Circuit, I would think, that, quote, where an immigration judge finds that a Form I-213 is unreliable and insufficient to establish alienage, he or she must point to specific evidence in the record sufficient to rebut the presumption of reliability, end quote. According to the BIA, no I-213 issue was identified by any party here. What's more, it definitely didn't help that Mr. Mercado-Martinez's attorney apparently admitted alienage in his written pleadings, which I'll admit you probably shouldn't do if your plan is to put DHS to their burden on alienage. With alienage deemed met, the burden then flipped to Mr. Mercado-Martinez to, quote, either rebut such evidence of alienage or demonstrate the date, time, and manner of his entry, end quote. Apparently and somehow this issue too, or maybe alternatively, was decided by the IJ. I am getting slightly confused. But an IJ deemed Mr. Mercado-Martinez credible, believing then that in fact, and I guess in the alternative, he actually had entered following inspection, and he had possessed an entry document, so he wasn't inadmissible, even if alienage had been established, which again, the IJ held had not been established. Kind of confusing, but apparently that's what happened. As such, and as much as the BIA may want to reverse that finding, or may not, I don't know, the BIA recognizes that it lacks fact-finding ability as an appellate body. Deeming the IJ's fact-finding incomplete on the issue, the BIA remanded for the IJ to do more work on that second issue, that is, whether even if alienage had been established, Mr. Mercado-Martinez rebutted the allegation that he was inadmissible under either or both INA Section 212A6AI as an EWI or 212A7AII as an applicant for admission lacking proper immigration documents. And it's going back for that reason. And that is matter of Mercado-Martinez. Our second case from the BIA this week is matter of Lopez-Orellana. Can't believe deficient notices to appear are back on the podcast. But would the pod even be what it is without them? I feel like we kind of grew up together in a way, and that's beautiful to me. Pro se case, too. The NTA in this case lacked the date and time of the first removal hearing in violation of the INA, something that it appears only DHS is allowed to do without meaningful consequence. Mr. Lopez-Orellana failed to appear at 2 hearings. At that second hearing, the IJ terminated proceedings based on the NTA deficiencies. This explains the BIA, despite follow-up hearing notices being sent to Mr. Lopez-Orellana, apparently. Now, DHS tried to amend the NTA with the Form I-261. The IJ rejected that attempt, and as it turns out, rejected that attempt properly. Unsure if it was published yet, but the BIA, of course, would come to hold that DHS can't amend a deficient NTA with an I-261. Matter of Aguilar-Hernandez, episode 197. Uncited anywhere in this BIA decision vacating the IJ's termination order on DHS's appeal. On a technicality, really. Explains the BIA, an objection to a deficient NTA is for a party to make, not a neutral arbitrator. And because Mr. Lopez-Orellana wasn't at the hearing, he couldn't raise the objection. That's how they get you. Not only that explains the BIA, but since the IJ's order, the Supreme Court has issued Campos-Chavez, and the Fifth Circuit, where these proceedings originate, issued Luna v. Garland. Taken together, explains the BIA, the IJ needed to go in absentia and order Mr. Lopez-Orellana removed, if, of course, DHS established removability, and now, if Mr. Lopez-Orellana doesn't show up for a new hearing after being deemed to have received new, legally sufficient notice. Which is why it's all being sent back now. Another day. Another decision streamlining the ability to order non-citizens removed and limiting the ability of IJs to exercise discretion and manage their dockets in a manner that benefits non-citizens, when the IJ believes, of course, that it would be warranted in an individual case. And that is matter of Lopez-Orellana. Moving on with Perdomo Ulloa v. Bondi, published by the Fourth Circuit on March 25, 2026. This is a fairly short immigration decision that I suspect may not be doing the petitioner's arguments full justice. Mr. Perdomo has been in the United States without authorization since 2000 and wants to apply for non-LPR cancellation of removal in removal proceedings. But he can't do that if his 2012 Class 1 misdemeanor conviction, in violation of Virginia Code Section 18.2-186.3 A2, for using another person's identity to, quote, obtain money, credit, loans, goods, or services, end quote, is a CIMT. By the way, it also requires an intent to defraud. Now, even if it's a CIMT, it only bars Mr. Perdomo if it's a crime, quote, for which a sentence of 1 year or longer may be imposed, end quote. In Virginia, Class 1 misdemeanors are punishable by, quote, confinement in jail for not more than 12 months, end quote. Mr. Perdomo received a suspended sentence of 30 days in jail. Sounds like Mr. Perdomo is in trouble as written by the Fourth Circuit, and he is. First, the conviction is a CIMT. Indeed, Mr. Perdomo conceded that issue at oral argument, surely because the Fourth Circuit made that exact ruling in Salazar v. Garland, episode 141. The petition for review then all comes down to whether a Class 1 misdemeanor of this statute is a conviction for which a sentence for 1 year or longer may be imposed. The Fourth Circuit explains that, like many circuits before it, a possible sentence of merely 1 year satisfies this standard. And it believes that's what Virginia does with Class 1 misdemeanors. Mr. Perdomo first argued that 12 months doesn't equate to 1 year in this context. Virginia makes clear the distinction, legislating that felony offenses are punished by at least 1 year in prison, while Class 1 misdemeanors are punished by a maximum of 12 months. So that must mean something different, right? Why else would the legislature do that? Misdemeanor convictees also have other potential benefits, including but not limited to the fact that they may ultimately be able to get released earlier. As such, a Virginia Court of Appeals held in their 2022 Belcher decision that, quote, when it comes to criminal sentences in Virginia, 12 months is not simply another way of expressing 1 year, and the phrases do not mean the same thing, end quote. Starting to seem like a dang good argument to me. Not to the Fourth Circuit. Yes, misdemeanor and felony offenses are treated differently in Virginia, but not for purposes of the amount of time the convicted individual can spend in prison. Whether the 12-month ceiling for misdemeanors or the 1-year floor for felonies, the Fourth Circuit sees that as the same amount of time. Quote, notably absent from Belcher is any suggestion that a 12-month sentence is somehow shorter than a 1-year sentence, end quote. And to the contrary, the Belcher Court apparently recognized that months mean calendar months, and year means calendar year, meaning that 12 calendar months equals 1 calendar year. Next, the Fourth Circuit rejected the argument that to meet this CIMT bar, the crime must carry a possible sentence of 1 year, and a possible sentence exceeding 1 year. The statute uses the word or. That's a disjunctive. 2 different ways. The sentence must either allow for a 1-year sentence or more than 1 year. Need not be both. Finally, Mr. Perdomo argued that, quote, the phrase 1 year or longer actually means more than 1 year, end quote. As he explained, quote, a crime for which a sentence of 1 year or longer may be imposed is a term of art that means felony, and crimes are generally classified as felonies if they are punishable by more than 1 year, end quote. To support this, Mr. Perdomo relied on the legislative history wherein Congress intended, apparently, this bar and the attendant removability provisions to apply to felonies. But even if true, and I don't think the Fourth Circuit is convinced, legislative history cannot override the statutory text as the Fourth Circuit sees it, meaning that the court denied Mr. Perdomo's petition for review. And that is Perdomo Ulloa v. Bondi. We conclude with 2 from the Ninth Circuit. First, United States v. Chavez-Echeverria, published by the Ninth on March 25, 2026. This is a sentence enhancement crime of violence case that did not come out well for the anti-crime of violence crimmigration bar. There are far too many of these, and because they don't pertain to immigration necessarily, I don't usually do them. That is, those bad for non-citizens by extension arising in the sentence enhancement context. But this one is actually on all fours with immigration. It's about what constitutes an attempted use of physical force, which is the exact same phrase used in the immigration crime of violence definition. The statute at issue is Oregon Attempted First-Degree Assault, Oregon Revised Statutes Sections 163.185(1)A and 161.405. I'll try to be quick. The completed crime requires, quote, intentionally causing serious physical injury to another by means of a deadly or dangerous weapon, end quote. Everyone agrees that's a crime of violence, so we're kind of halfway there. But is attempting to do it then an attempted use of physical force? Because recall, an attempt to do a crime of violence does not necessarily constitute a crime of violence itself, because it doesn't necessarily require an attempted use of physical force. That's kind of what the Supreme Court's recent Taylor decision says. The issue then comes down to whether Oregon uses the same or materially similar attempt definition to the federal government, at least in the sentence enhancement context. An attempt to commit a crime occurs in Oregon, quote, when the person intentionally engages in conduct, which constitutes a substantial step towards commission of the crime, end quote. Restated, the Oregon courts have explained that you've got to take a substantial step towards causing serious physical injury. Under Oregon law, quote, a substantial step is conduct that, 1, advances the criminal purpose charged, and 2, provides some verification of the existence of that purpose, end quote. Mere preparation is not sufficient to convict on an attempt. And that's all consistent with the Model Penal Code, too. It's also all consistent with the Ninth Circuit's attempt requirement for sentence enhancement purposes and likely immigration as well. Many pages on that, mostly coming down to a Ninth Circuit decision, the Linehan decision. but summed up, quote, to constitute a substantial step within the meaning of the force clause, conduct must go beyond mere preparation and must be strongly corroborative of the firmness of a defendant's criminal intent, end quote. That's facially identical to what Oregon requires, explains the Ninth Circuit. It's substantively so, too, rejecting multiple of Mr. Chavez-Echeverria's arguments, including his reading of other Ninth Circuit authority and other things inapplicable to immigration. And so, Mr. Chavez-Echeverria gets more time for his, you guessed it, federal conviction for felon in possession of a firearm, because of his prior Oregon offense. And that is United States v. Chavez-Echeverria. You didn't go to law school to enter data. I know I didn't. Yet here you are. H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Ristova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. Concluding with Navarrete v. Bondi, published by the Ninth Circuit on March 23, 2026. This case is very complicated, and it's about reasonable fear review. Sit back, relax, and enjoy the jurisdiction. Mr. Navarrete is from Mexico. He attempted to enter the United States with another person's green card in 2003 and was expeditiously removed that same day. He entered illegally sometime after that, and when DHS figured it out, his final order of removal was reinstated. That was in 2024. DH learned about him, by the way, because his employer turned him in. To avoid imminent removal, Mr. Navarrete asserted that he had a fear of return to Mexico. That means he received a reasonable fear interview to see whether he would be placed in withholding-only proceedings, where he could apply for withholding of removal or protection under the Convention Against Torture, vis-a-vis Mexico. But only if an asylum officer believed that he had a reasonable fear, and the asylum officer here did not. An immigration judge affirmed that no reasonable fear finding de novo, and so, pursuant to Ninth Circuit precedent, Mr. Navarrete petitioned for review that directly to the Ninth Circuit. Now, although Mr. Navarrete petitioned for review within days of the no reasonable fear finding by the IJ, that petition for review was well more than 30 days after DHS reinstated the removal order. That used to be par for the course in the Ninth Circuit and like everywhere. And that was the law too when Mr. Navarrete's attorney did this. But the rug was pulled out from under Mr. Navarrete when the Supreme Court issued its Riley decision last term. To Oil's credit, they did not urge the circuit to dismiss the petition for review as untimely for that reason. They didn't assert the mandatory claims processing rule that Riley now instituted. But the Ninth Circuit dismissed the petition for review. First, it went through the very complicated and at times intertwined jurisdiction stripping provisions and jurisdiction granting provisions that govern the issue. But at the end of the day, it really comes down to the Supreme Court's recent decisions in Nasrallah and Riley, and those decisions' holdings about what constitutes a final order of removal. Because circuits only have jurisdiction to review final orders of removal, explains the Ninth Circuit. Obviously, that would be where the BIA affirms a removal order and denies relief, but also, quote, review of a final order of removal includes all matters on which the validity of the final order is contingent, in addition to those determinations actually made at the removal hearing, end quote. But, quote, by contrast, if the requested administrative relief is not inconsistent with the removal order, then the denial of such relief does not merge into the final order, end quote, and can't be reviewed. What that means is, per Nasrallah, for example, you can petition for review Convention Against Torture denials within 30 days of the BIA's denial, where that's all happening anyway, and removability is being conclusively established, because of that first quote. The validity of the final order is contingent on whether cat protection was properly denied. That's the rationale, I believe. But what is a no reasonable fear finding? Well, it's the latter. Quote, we have not been granted any jurisdiction to hear cat claims independent of challenges to final orders of removal, end quote. As such, in relying heavily on Justice Thomas's concurrence in Riley, the Ninth Circuit holds that cat orders can only be reviewed when they're reviewed alongside a final order of removal. And that's not what's happening here. Heck, the denial of cat protection isn't even technically at issue yet. It's about a no reasonable fear finding. Now, the persistent and very smart Amicus Center for Immigrant Rights came in on amicus to argue that actually, the Supreme Court's Monsalvo v. Bondi decision, episode 261, compels a different result. That's the decision where the Supreme Court allowed the 60-day voluntary departure period to run to the next business day when it fell on a weekend. Recall? To get there, explains the Ninth Circuit, the Supreme Court rejected the Solicitor General's argument that Mr. Monsalvo, quote, was required to bundle his question about the operation of his voluntary departure deadline with some challenge to the board's conclusion that he was removable, end quote. Pretty smart. The Ninth Circuit is tempted. But Nasrallah is truly directly on point with the cat stuff to the court, and in that case, the Supreme Court made clear that cat is separate from a final order of removal. Can still be reviewed alongside a final order of removal, but only when alongside a final order of removal. No such clarity exists with voluntary departure, nor will it be forthcoming, I would think, and hence VD is different. Reading all this recent case law together, the Ninth Circuit holds that, quote, a final order of removal includes all rulings that condition or extinguish the executive's authority to remove a non-citizen altogether, but not those rulings that merely condition or extinguish the executive's authority to remove a non-citizen in a certain manner, end quote. Voluntary departure merges into final order review, even though there's technically no final order before voluntary departure expires, right? CAT is different because a non-citizen can be removed somewhere else when CAT is granted. As we're seeing all the time now, really. The Ninth Circuit goes on to explain that its holding is indeed retroactive, even though Ninth Circuit precedent used to hold otherwise because, quote, a jurisdictional ruling may never be made prospective only, end quote. Recall, this is jurisdiction, even though Riley wasn't, because the Ninth Circuit is saying that its jurisdiction depends on final removal order review, and it sees no final removal order challenge before it. Mr. Navarrete's removal order, which was already reinstated, is, I suppose, about to be executed. And post-reinstatement reasonable fear petitions for review, and even CAT denials, are on life support in the Ninth Circuit. And consider this. Query whether Mr. Navarrete could have avoided all this, had he known, by petitioning for review the reinstatement decision of DHS within 30 days of reinstatement, and then later additionally petitioning for review the no reasonable fear finding. And then I guess having those petitions merge into one mega petition. That seems to me to be what some circuits and even the Riley court have said is possible. Candidly, I'm not 100% that would have saved him here given the Ninth Circuit's reasoning. Part B at the end and footnote 5 are concerning. Seems like Mr. Navarrete urged the Ninth Circuit to let him do this after the fact. But it's certainly worth a try and is indeed maybe the only option available. Better invoke a colorable claim to petition for review. That reinstatement order, though, all but explains the Ninth Circuit. Things are getting quite dangerous and difficult post-Riley in post-reinstatement petition for review land. As the Riley court recognized, they knew it was coming. And that is Navarrete v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Oh. Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.